For decades, otherwise lawful gun owners have been denied their rights protected under the Second Amendment due to a federal law. Now, the Fifth Circuit Court of Appeals just decided a case claiming that law is unconstitutional as applied to Mr. Hembree. So let's take a look at this case next on the Constitution Study.
Neighbors and have a few good friends. Every day we're everyday Americans. Oh, every day we're everyday Americans.
Hello there, everyday Americans. Paul Engel here with the Constitution Study, where we read and study the Constitution. Teach, rise, and generation be free. Glad you could join me today. As a gun owner, I always thought people who lost their rights, not only under the Second Amendment, but their right to vote for conviction of a felony was a step too far. I'm not saying there aren't people who shouldn't lose their right to vote or to carry firearms, but I just thought the level was just too low. Now, with the Fifth Circuit decision on the Hembree case, at least the felon in possession is now questionable. I'm not saying other circuits won't decide differently, and what the Supreme Court might look at some later date, we don't know. But I want to take a look at this case. Now, if you want to follow along, head to the website, constitutionstudy.com. You can find the article. And the best part is all of my quotes have links, so you can check my sources, make sure I've got this right. So now let's take a look at this case with Mr. Hembree. People familiar with the Second Amendment and the laws around it are probably also familiar with the term felon in possession. While many states have felon in possession laws, the law in question in this case is 18 U.S.C. section 922 G1, which reads, "It shall be unlawful for any person who has been convicted in any court of a crime punishable by imprisonment for a term exceeding 1 year to ship or transport in interstate or foreign commerce or possess or affecting commerce any firearm or ammunition, or to receive any firearm or ammunition which has been shipped or transported in interstate or foreign commerce." Well, I believe most Second Amendment advocates would agree that convicted violent felons should be legally prohibited from possessing firearms. As our laws have grown, more and more crimes have been put on the books with a punishment of 1 year or more. Now, should someone lose their rights protected under the Second Amendment for a non-violent crime? That was the question heard by the Fifth Circuit in the case USA versus Hembree. Hembree was convicted in 2018 of possession of methamphetamine in Mississippi State Court. In 2022, Hembree was charged with possession of a firearm by a convicted felon in violation of Section 922 G1. He filed a motion to dismiss the indictment, arguing that 922 G1 violates the Second Amendment as applied to him in light of the Supreme Court's decision in New York State Rifle and Pistol Association versus Bruen. The district court denied this motion on December 2023. Having been convicted in 2018 of possession of methamphetamine may not put Mr. Hembree in the most favorable light to many Americans, but does that justify the loss of his rights? He contends that the government has not and cannot prove that disarming Hembree based on his conviction for possession of methamphetamine fits within the country's traditional regulation of firearms. This calls back to the New York Supreme Court case, New York State Rifle and Pistol Association v. Bruen, where the court laid out a two-part test for laws that infringe on gun rights. First, does the action prohibited fall within the plain language of the Second Amendment? And second, does it fall within the history and tradition of firearms regulation in the country? I'll go into that deeper in this section on New York State Rifle and Pistol Association v. Bruen. Hembree also raises 4 challenges for the first time on appeal: that 922 G1 is facially unconstitutional under the Second Amendment, that Section 922 G1 is unconstitutionally vague, that 922 G1 violates the Commerce Clause, and that 922 G1 violates the Fifth Amendment's Equal Protection Clause. The government contends that these challenges were waived by the appeal waiver in Hembree's plea agreement, which only preserves his as-applied challenge. Because of how the court found in Mr. Hembree's as-applied Second Amendment challenge, they did not bother to look into other claims. However, a concurring opinion did discuss the Commerce Clause question, which I'll cover later. Since the court's analysis focused on the Bruen case, I think it's worth taking time to review it here, starting with how the circuit courts have applied the SCOTUS precedent in regards to this law. Circuits have diverged in application of Bruen's framework. Many of our sister circuits have held that 922 G1 is constitutional as applied to all felons. This is for United States versus Mancilla. Thus far, the 2nd, 4th, 8th, 9th, 10th, and 11th circuits have taken this approach. In Diaz, however, we recognize that 922G1 could be unconstitutional as applied to certain predicate felonies. So 6 of the circuits have found 922G1 to be constitutional. While the court often refers to Diaz in this opinion, like so many other courts, they place their previous decisions above the supreme law of the land. However, not all of the circuit courts have followed suit. Separately, the 3rd and 6th courts allow as-applied challenges to 922G1, and both circuits require district courts to make individualized determination of dangerousness when adjudicating these challenges. Courts in those circuits consider the person's entire criminal history, including the predicate offense and its underlying conduct. So just because a person is a felon, are they automatically considered dangerous? I've heard a report that claims the average American commits 3 federal felonies a day. It's an example of how the bureaucracy, accompanied by vague laws, makes felonies out of everyday life. However, the definition of a felony is a serious crime, not necessarily a violent one. The Free Legal Dictionary defines a felony as a serious crime characterized under federal law and many state statutes as an offense punishable by death or imprisonment in excess of 1 year. Before we get into the discussion of dangerousness, let's wrap up the Bruen discussion with a look at historical analogs. First, the government points to historical laws authorizing severe punishment for knowing possession of contraband, arguing that these laws shows that permanent disarmament of those convicted of possessing illicitly obtained goods today, like Hembree, is consistent with the Second Amendment. Hembree takes a narrower view of the historical analog. He cites that until a century ago, there was virtually no effective regulation of narcotics in the United States. The government points to historic severe punishment for the possession of contraband. But did that include depriving people of their rights protected by the Constitution? And according to Mr. Hembree, until a century ago, there was little, if any, regulation of narcotics in the United States. So how can there be a historical analog for this punishment? I think most reasonable people would consider the deprivation of right to keep and bear arms reasonable if someone is convicted under due process of law of a crime that shows they are dangerous to others. But does that simple drug possession show someone is dangerous? The government's second historical basis for permanently disarming Hembree is that our nation has maintained a history and tradition of disarming dangerous individuals. Specifically, the government reasons that drug crimes are inherently dangerous, even in situations where a defendant has only been convicted of mere drug possession, like Hembree, because the possession of narcotics entails the dealing and enriching of drug traffickers. This seems to me to be an artifact of the nation's war on drugs. The idea that drugs are dangerous whether or not the person involved has shown any sign of violence. Why? Because possession means you enriched a drug trafficker. And we all know that drug traffickers are involved with dangerous cartels. So it's not the drug possession that's dangerous, but the purchase. This raises another problem for Mr. Hembree. In my mind, that is subsection 3 of 922G, which reads, who is an unlawful user of or addicted to any controlled substance as defined in Section 102 of the Controlled Substances Act. 22 U.S.C. 802. Can we logically assume that someone in possession of drugs is a user or addict of said drug? Since the government did not charge Mr. Hembree with the violation of 922G3, I can only assume they did not have evidence of his use or addiction to methamphetamines. Furthermore, look through the Constitution all you want, and you will not find a power delegated to the United States to control substances. Congress can control foreign and interstate commerce, but not the product itself. That means the Controlled Substances Act itself is unconstitutional and void. So how could someone be in possession of a substance controlled by an unconstitutional law? Judge Don R. Willett offered a concurring opinion where he focused on the Commerce Clause claim, which the main decision did not consider. As I have previously explained, 18 U.S.C. 922G1, the federal felon in possession ban, rests uneasily alongside a bedrock principle. Every law enacted by Congress must be based on one or more of its powers enumerated in the Constitution. Given the expansive interpretation of the commerce power, the natural first place to look is the Interstate Commerce Clause, which grants Congress the power to regulate commerce among the several states. Perplexingly, the Supreme Court once declared this power is not confined to the regulation of commerce among the states. More recently, however, the court has endeavored to more sharply define and enforce limits on the commerce power, confining it to 3 general categories. Amen. How often have I pointed out that Congress writes laws against things that have traveled through interstate or foreign commerce, but not the commerce itself? How did they get away with it? Based on SCOTUS's unwillingness to follow the Constitution of the United States. They allowed Congress to violate the supreme law of the land. While the court may claim to have endeavored to help clean up the mess they've made, I've seen extremely little evidence to support that. The judiciary should heed that lesson as well. In an appropriate case, I remain open to reconsidering whether 922G1 truly falls within Congress's enumerated powers. For now, however, I will join the majority's conclusion that 922G1, as applied here, violates Hembree's right to keep and bear arms. I do hope that Judge Willett gets the chance to reconsider whether or not 922G1 falls within Congress's power, and I hope he gets the chance very soon. Before we look at the court's decision, what do you think? Should Mr. Hembree be denied his right protected by the Constitution of the United States for possession of a controlled substance? Instead of this, does a deprivation of rights for a nonviolent felony violate the Eighth Amendment's prohibition against cruel punishment? Cruel is defined as willfully causing pain or distress, merciless. Does a deprivation of rights for a nonviolent felony cause pain or distress? Or is it merely merciless? Or is this a simple violation of the Fifth Amendment? While Mr. Hembree claims it violates the Fifth Amendment's Equal Protection Clause, there is no Equal Protection Clause in the Fifth Amendment. However, there is a Due Process Clause, which reads, "No person shall be deprived of life, liberty, or property without due process of law." Did Congress protect the rights of the individual when they deprived them of the property they have in their rights for a nonviolent felony? Should someone be deprived of their ability to defend themselves when they've not been shown to be a danger to others? Should someone be deprived of their liberty to exercise their right simply because the government claims that someone else did something dangerous in order for that person to gain access to the substance? This court did not consider any of these questions. They simply followed what others had said. Our court's 922G1 case law has rapidly evolved and continues to do so. But we are bound by our precedent, pending further clarification from our full court to reconcile our incremental approach, or from the Supreme Court to reconcile the circuit split. We therefore find the government did not meet its burden to prove that history and tradition support simple possession as a valid felony predicate under 922G1. We decline to reach so far as to find possession to be part and parcel with the drug trade, and government's analogy to possession of contraband has been foreclosed. Accordingly, we are compelled to reverse Hembree's conviction as unconstitutional as applied. This is another example of a court coming to the correct decision, even if based on the wrong standard. After all, the judges swore an oath to uphold the Constitution, not their precedents. Now, if we can only get Judge Willett the case he asked for. I am curious what you think, because I found that felon and possession laws often come with strong emotions. And I'm curious, is simple possession a mark of dangerousness? A dangerousness to whom? Does the fact that possession means it was at some point purchased from a dangerous person mean that you're dangerous yourself? It's an interesting quandary. And if the statement is correct that we commit 3 federal felonies a day, how could any of us possess a firearm? It's interesting. Like I said, it often evokes strong emotions. And I hope you'll comment. I hope you'll join in. Now, if you want to find out more, again, you want to check out the article, you want to comment on it, head to constitutionstudy.com. You can find the article. You can comment on it or on my videos on YouTube or Rumble. Take your pick. The advantage of checking out the website is you can check out all my links and double check my work. Now, hopefully you'll love to support the work that we're doing here. You like it enough. You can do that by going to the store, constitutionstudy.com/shop, and purchasing something. A book, a t-shirt, a mug, or just donate to the cause. There's a donate page there as well. All of it goes to keeping the Constitution Study up and running. Nothing, we don't take a salary. We don't get anything out of this. It's about keeping this program up and running because I think there's value to it, and I hope you do as well. You can also support us, by the way, with your cell phone. Patriot Mobile is America's only Christian conservative wireless provider. Best of all, they take a portion of every dollar to support organizations that are protecting your rights. That now includes the Constitution Study. That means if you go to patriotmobile.com/constitution and you find a plan that works for you, every time you pay your cell phone bill, you're helping to support the Constitution Study. Oh, by the way, check out the discounts. Everyone from veterans and first responders to families with multiple lines can get a discount. And if you use the code Constitution at checkout, you'll get your new line activated absolutely free. Not a bad deal, and supporting the Constitution Study as well. Once again, by going to patriotmobile.com/constitution, finding a plan and discount that works for you. And don't forget to use that code Constitution at checkout to get your new line activated absolutely free. Most of all, I hope you found this educational, informative, and maybe it gave you an impetus to learn more, to go forth and read and study the Constitution, to learn to defend and assert your rights. And, well, hopefully it also encouraged you to tell other people, maybe even bring them back here next time for the Constitution study.
Love your neighbors and have a few good friends.